Um, sh- okay.
Anvesha, you can start.
Okay. Okay, so I welcome you all and good evening to all the participants, panelists, and attendees present here. I welcome you all to the today's webinar on criminal justice system and police administration during COVID-19, uh, social pluralism. We are looking forward to hearing from our distinguished jurists and panelists here. We shall begin with our director, Sir Professor Avian Rao, giving his welcome address. Professor Rao is a distinguished academician and he has 20 years of industrial and teaching experience. And he has written more than 50 research articles and has published in various national and international journals. I welcome you, sir, and I welcome all the other panelists sitting here. I hand it over to you now. Sir, you need to unmute yourself.
Yes, I unmuted. Are you hearing me?
Yes, sir, we can hear you, sir.
Thank you, Anvesha. Good afternoon to you all. Honorable Justice Prakash Rao Garu, Honorable Justice Banu Garu, Honorable Mr. Malakonda Garu, former DGP of AP High Court, the AP State, and our faculty members, advocates, students, and other members who is participating today. Today we are talking on a very important topic which is very relevant and apt. Topic you know very well, criminal justice systems and police administration during COVID-19, a social pluralism. A social pluralism is a very important fact now. What's a pluralism? It is nothing but a doctrine of multiplicity or diversity within the unity or within the society what we are having it. Social pluralism in society, we have different kinds of strata, different kinds of the people, different kinds of the religions, different kinds of states people living together. All people are coexisting with one another. Similarly, with the criminal justice system, in order to maintain law and order situation and reduce, minimize, and mitigate the crimes across the society, and also the police administration is there as a part of the criminal justice system, and also to maintain the law and order system in the country, in the society. So, police department and the criminal justice system, they play different kinds of roles as a part of social engineering, as a part of administering these law and order situation in the society, and also protect the rights of the people. Let us take the police administration for example. It has three different kinds of functions. One, as a part of the criminal justice system, it makes a lot of investigation, helps the system to come with a justice to a person who is a victim. That's one of the functions the police administration undertakes. Another is it maintains law and order by protecting individual rights of the particular part. Under present situation, that is during COVID pandemic situation, it is another great role to play. That great role is to stop the people from gathering and enforcing the health emergency regulations or directions given by government in order to control, in order to avoid and evade the connectivity between the people to control the pandemic spread. So if you take these two, three different kinds of the roles, a person is having the right to move freely. But here, the system, the police department is trying to stop the people's movement. There are two different kinds of the contra works they are giving. Though the police department is administering for the purpose of minimizing the contacting or to protect the social distancing part, it is one of its functions under the present position. But it is giving some kind of problem to the people's movement. how these two things are to be balanced. Criminal justice system also is to fix the liability on the victim and the offenders, minimizing the offenders and minimizing crimes in order to protect the social order, society order. However, this pandemic has stopped the process of the criminal justice system to some extent. Courts are not functioning. Investigation is not being done perfectly to its 100% because of shortage of the police people, shortage of the investigators, or shortage of people diverted for that particular other activity. Like this, we have pluralism in everywhere. Social living, we have the pluralism. In functions of the police administration, we have the pluralism. We have the pluralism in the criminal justice system and the judicial activities part of it. So this particular under these circumstances, how there should be coordination and coexisting, working together among these two important wings of the society in order to protect the society from different kinds of disasters. We have the good panelists here, well-learned panelists here, two former judges of the High Court of Andhra Pradesh and one DGP of AP government who has extensively done his police administration throughout his life. Let us hear the panelists now in order to see how the pluralism in the society will be protected or people in the society will be working together in order to achieve only one goal. That's a criminal justice system. The other goal is minimizing the pandemic for the betterment of the society. Let us hear this. I welcome all of you once again. I request Anvesha to proceed further.
Yes, thank you, sir, for such a good introduction. I will now, I once again welcome Justice Prakash Rao, sir. Sir is a distinguished jurist and he practiced at the High Court of Andhra Pradesh from 1972 until he was elevated as a judge of the High Court in 1999. He also served as the president of Andhra Pradesh Judicial Academy, was the executive chairman of Andhra Pradesh State Legal Service Authority, and was appointed as standing counsel for Andhra Pradesh State Road Transport Corporation. He has also served as an adjunct professor at Alsar as well as ICFI Law School, Hyderabad, for a long time. And I welcome you once again, sir, and I hand it over to you. We are looking forward to hearing all the enlightening views. Sir, I think, yes. Uh,
Justice Prakash Rao, sir. I think
it's a little bit of connectivity issue on his end.
it is because of internet connection. Maybe we
Connection
can wait
issues,
for a
yeah.
minute. Justice Prakash Rao, sir, are you able to hear me?
Yes,
Yeah, thank you, sir.
I can. Are you hearing?
Yes, sir. Thank
Yes,
you.
You
sir.
hear me?
Yes, sir, we
Yes, sir.
can.
Yes.
Yes, sir.
A very good afternoon to you all. Again, Mr. ICFA University, former judge of erstwhile Joint High Court of Andhra Pradesh, General of Police, Government of Andhra Pradesh, and all the participants, attendees, faculty, staff, ladies and gentlemen. To begin with, Mr. A.V. Narsura Garu for successfully continuing the webinar series on varied topics, adding to the legal awareness and knowledge to the various walks of life, including especially the faculty and also the students. Today's topic is a very burning is criminal justice administration during COVID. Now we are all aware under the Constitution The three entities, legislature, the entire legal system, be it civil or criminal, and its administration hinges upon both the executive and the judiciary. Cannot simply be without the assistance and active participation of the police. The political and justice delivery. Offender should not go unpunished, and victim should not remain uncompensated in the core object of the criminal justice system. As you are aware, man is a social animal. It has been said by Jeremy Taylor in Works 13, a herd of wolves is quieter and more at one a common power to keep them all in harmony. The most forms of society. Fund. A society in which the power of state is never called into actual exercise marks the disappearance of governmental control, but the final triumph and supremacy of it. Phenomenon threatening the mankind, trying to wipe out the species of Homo sapiens from the portals of the earth. Already many fatalities occurred and large numbers are afflicted with and undergoing treatment in almost every country and even in the city of Hyderabad where we live, in almost every corner, gully and lane. Threatening fear, complex and danger is looming large. The respective governments and the administration have ushered in many preventive measures, including imposing lockdowns. The prohibitory measures imposed made almost every town, city, a deserted. Under these measures, everyone is locked inside their houses. With the advent of COVID, there is a new entry, new phase, and now the ultimate conclusion at the administration level is you should learn to live with the COVID. Live and let live. Just as COVID is having its day, why not allow our social activities three wings with all the precautionary measures like social distancing, masks, etc., and advancement and availability of technology support, online can successfully make inroads into pluralist ways of working the socio-criminal system and its administration. Almost now, every walk of life, every activity, be it a profession, vocation, business, labor, or any employment for that matter, or any for livelihood, has come to a grinding halt. Even the working systems under the three wings of the constitutional arrangements opted surprisingly a no work formula. Are closed. Pending cases continue to sleep over. Pending investigations is already committed crimes is slowed down without any progress. Only urgent matters, especially like bails or any interim measures, are being taken up with difficulty. Regular courts and regular hearings not seeing the light of the day. Even urgent matters are taken up through virtual hearings. Man, as you know, a social animal in the society. A crime results when there is social activity and movement. Everyone now locked inside, no activity, no movement, no crimes. Has everybody become a good boy? According to some social activists, domestic violence has increased. Does it indicate that everything is normal and perfect on law and order? Has crime rate has dashed no no registration of crimes, even on lifting of lockdown or relaxation thereof. Social distance bar keeps everyone at bay. There is going to be a sea change in the mindsets. Can the present situation has any semblance to the period under the emergency? May I ask you, like, just to compare the situation now with this COVID period? During the emergency, fundamental rights and its enforcements are suspended, though courts continue to work. Follow-up was more arrests and lockup, whereas under the situation, no rights are suspended. But the courts and governmental agencies, offices, tribunals, etc. are closed and shut down themselves. Further, under the notifications issued under the COVID situation, several permissions are contemplated for movements, get-togethers, and several other activities. Has the police Raj made a complete comeback? What a contrast! One may ask several questions, several doubts may crop up. The civil society, constitutional system, rule of law, human rights. Look at all these from twin angle. Suppose I am a prospective offender. Where do I stand? Are the surrounding situation at large quite amenable or disadvantageous? Normal circumstances, no access to lay even my bare pass. Is it more easier for hand of law to reach me? Should I or not? Should I not proceed to commit the act? Side of the coin. Suppose I am a victim. I could be just prior to the imposition of lockdown or even during the lockdown. Where to go? Does does whom to complain? Not easier to just my protection of human rights, my protection of liberty under Article 21 of the Constitution of India, whom to address? No courts are functioning. Cases continue to drag on. No hearings. No serious investigations. The situation on the ground is totally different. The administration always has some excuses and explanations. Delays in the administration of justice are held to be very bad by repeating the constitutional courts and violation of Article 21 of the Constitution. It has been said on judicial side that already to ensure accommodation facilities to the migrant workers and safety measures and precautions to the, to the prisoners in the jail, and no collection of fee in private schools where no classes are held. No work, no pages, not applicable. Quarantine cannot be restricted to 14 days. No hyper legislative interpretation of guidelines by the government, and limitation for filing the final reports under 167 CRPC not being extended. Quarantine is always 24/7 on. The system goes. The provisions of the Disaster Management Act does not contemplate the directions or the scheme to see that the work goes on in every office. The moving wheel of administration under all the three wings should always be on. Sociologically, looking at the continued pandemonium, the system is going to face new challenges. The crimes and the thought behind it, the administration of justice and punishing the offender has to have improvised or new approach. The existing law may not be able to cater. The law is always known to be 10 years behind, whereas the offender is 10 steps ahead. For COVID, it will see a different situation. Faced with this, it really wonders and expresses. I am just trying to put as far as my institution is concerned, the functioning of the courts expresses doubt. See the presence and participation and the police authorities is quite, since all the courts are closed. Agency are being taken up by holding virtual court hearings. Whereas the situation totally stands different in regard to the appeals, revisions, quash proceedings, depending on the file of the appellate courts, starting from the district court to honorable high courts and honorable Supreme Court. As it is, the dockets are swelled up. Even prior to COVID, there is a grievance of delays in disposal of the cases. The contributing factors could be varying. However, under the aegis of the Honorable Supreme Court and the substantial financial assistance from the central government, all the courts, all the tribunals, all the judicial authorities, quasi-judicial authorities also sufficiently provided with all the systems and facilities. The records in the cases are also scanned and readily made law available long back. One phase was already over and second phase is still on. There is no reason as to why the appellate courts can hold virtual hearings every day with the cooperation of the bar by giving notices to them and give disposal every day. The common litigant is put on hold and continue to stare at with great expectations. Where there's a will, there's always a way. The entire corporate world has already shown us the way by guiding the work from home. The corporate activity is very much running and moving forward. Why not we? The educational institutions, schools, colleges are already functioning with the online classes and courses are being completed. Webinars have become regular and routine for every and sundry of subjects. There is no dearth of attendees. The provisions of the Disaster Management Act do not contemplate any working system to stop. This is a very crucial aspect. Instead, the authorities have to give proper directions to function every office. Learn to live, learn to work with the methods available. Running the institutions are signs of living democracy. Closure of any institution under all the three wings means is a totally a constitutional breakdown. Maybe these are the days of more self-restraint. Follow strictly the health measures, safe distance, mask, washing hands, and avoid gatherings. Learn to work. Faith of common man, let it not be shattered. Let not litigant lose in the hovering mist. Work more jealously. Social pluralism should ably make a living. Otherwise, don't American black slave mother. Hush, my child, don't cry. My treasure, weeping its vain. The enemy will not pain, for the ocean has its limits. Prisons have their walls around, but our suffering and our torment have no limit and no bound. Questions and also do crop up. Several everyone will be asking as to how to approach and how to get the justice. I am only raising these queries. The answers will have a great bearing and help and come to the assistance of all those at the appropriate level to immediately respond. The emergency has taught us many things which were subsequently corrected and taken care. Lest not the present situation go without readiness. I thank the ICFI institution and in particular Mr. A.V. Nasura Garu for giving this opportunity. Thank you and thank you one and all.
Thank you, Justice Rao, for such an enlightening address to the gathering, and you've put all the relevant questions out there, which were the elephant in the room to say. Now we'll proceed, and I welcome once again Honorable Justice K.C. Bhanu, sir. I think he's sir. Are you there? We'll welcome him with a brief introduction. Honorable Justice K.C. Bhanu, sir, has practiced on the civil as well as on the criminal side in all courts at Rajmundry. He worked as an assistant government pleader and an additional public prosecutor at Rajmundry. He was then appointed as district and sessions judge, and he was promoted as district and sessions judge grade 1 and has worked as additional district and sessions judge, metropolitan sessions judge, principal district and sessions judge at various places in the state of Andhra Pradesh, including state places like Srikakulam and Guntur. He worked as a member secretary, AP State Legal Service Authority, Hyderabad, and as a metropolitan sessions judge, Hyderabad. He also served as Registrar General, High Court of Andhra Pradesh, and as a president of the AP Judicial Officers Association. He was elevated as an additional judge, High Court of Andhra Pradesh, in 2002, and sworn in as judge of High Court in 2004. He was nominated as the executive chairman of Telangana State Legal Service Authority, Hyderabad, and then retired in 2015. I welcome you again, sir, and we are looking forward to hearing your experienced opinion in this field. I hand it over to you now.
Okay, right. Thank you. Thank you, madam. My esteemed brother, Justice Prakash Rao Garu, faculty members, Narasimha Rao Garu, former DGP of Andhra Pradesh, Malkandai Garu, and Panigrahi. Good evening to all of you. I'm enjoying my retired life by giving lectures on various workshops being conducted by the district judges in the districts of Andhra Pradesh and Telangana, as well as now and then used to go to AP Judicial Academy, National Judicial Academy, Sardar Vallabhbhai Patel Police Academy, and also I have taken 3 or 4 classes through virtual conference to the judicial officers at the request of the present Chief Justice. And I must thank the ICFI School, Hyderabad, Law School, Hyderabad, for giving this opportunity to address you on the topic, the criminal administration system, especially during the COVID pandemic situation. As you all aware that crime is against the society. Society has to take care of the protection of its citizens. There is a reason why state law and order is the subject unlisted in the list 2 of the Constitution, where the state can amend the criminal law suitably to the need of the situations, in need of the crimes that are being taken place in the society due to improvement of the technology. And for well-being of the citizens, the state will enact the criminal acts or amendments to the existing criminal laws, penal statute, to protect the citizens in the society. The existence of the courts is founded on the investigation. If the investigation is strong enough, then the entire edifice of the structure or building would also be strong, and therefore the offender cannot escape unpunished, because the courts have no role to play in the investigation. It is exclusively the duty of the police or the investigative officer to conduct the investigation in such a manner that a person who has committed an offense should go unpunished. While I was practicing at Rajahmundry in the early 70s, at that time there are no multifarious duties on the police officer. They used to concentrate on the investigation so meticulously, and the IO who has conducted the case used to sit in the court hall from the day 1 onwards. That means when the trial has started till the date of judgment by the concerned court. That is the enthusiasm, that is the practice the investigative officer used to take care of. Because of various reasons in the society, that has now been changed. The investigations are the least importance to the police officers because of multifarious activities. They were entrusted with the other duties like securities, escort. If something goes wrong somewhere, they used to go there and do the bandobast duty. I saw a controversial film producer office was being attacked. The police went there and were trying to control the situation. Therefore, we are living in such a situation where the police are helpless. They are unable to conduct the investigation in a proper lines, in a scientific methods. Therefore, one of the judicial commissions recommended that a separate investigation agency has to be established only for the purpose of conducting investigation in the criminal cases. If a investigation agency is separately constituted, then they will bestow their attention. The police will bestow their attention on the investigation. They will try to see the conviction rate. If the conviction rate is increased in the society, naturally the crime would come down. When an encounter has taken place in Hyderabad, all the persons, all the people supported that encounter, though it is illegal. Even under the constitution, because one of the greatest articles, one of the great, very important article for every citizen of this country, Article 21, which says that no person shall be deprived of his life or liberty except in accordance with the procedure established by law. The procedure established by law is a case has to be registered, investigation has to be conducted, a trial has to be concluded, a fair trial has to be conducted, a reasonable opportunity has to be given to the accused. Then after giving evidence, the judgment will be pronounced. That is the procedure established by law. Why the people are, they want that offender should be punished immediately. If the punishment has taken place, no doubt, it will temporarily give solution to the people. But still, the rape and murders are being committed even after that encounter in both the states or throughout the country. So therefore, the punishment will, such severe punishments should be given to the persons who are found guilty in a court of law, so that there would be fear in the mind of people. If they commit those crimes, definitely they will fear to do any criminal act. As far as the investigation is concerned, in spite of various multifarious duties of the police officers, still some officers are doing their best by collecting the necessary evidence, by collecting the documents, by doing scientific investigation, and the guilty persons are being produced in the courts of law. I will tell you with my personal experience, sometimes some police officers, not all, how they manipulate the documents in a serious offenses. While I was working as a Metropolitan Session Judge, Visakhapatnam, I received an anonymous call anonymous letter saying that a young, beautiful under trial prisoner was subjected to rape by a warden in the central jail, central prison in Visakhapatnam. As you all know, crime is against society. Any person can set the criminal law into motion. He need not be a victim. He need not be a relative of the victim. He need not be a friend. Any person. So therefore, by exercising my powers as a chief judicial magistrate, I issued a letter to the central jail superintendent to produce her before my court. I recorded her statement in camera proceedings, except my bench clerk, typist, and myself. None was present. She narrated how she was being raped by the warden. Then I forwarded the letter with a covering, forwarded the statement with a covering letter to the central jail authorities. Police authorities. The police registered a case, conducted investigation, and filed the charge sheet before me. Because I was the Metropolitan Session Judge, necessarily all the cases, offences triable by sessions, the charge sheet should be filed before me. I saw this case also. The police, the inspector of police who was in charge of that investigation, never met me at any point of time after registration of the case. He has not examined me under section 161(3) CRPC, because when the investigation commenced, majority of you, all of you may know that they will record the statements and reduce into writing with regard to the facts relating to the offense. He never came to my office. He never came to my house to record my statement. The procedure contemplates that he should record. But surprisingly, I found my statement in that record. A total fabrication of record in a serious offense. Then I called the Commissioner of Police Visakhapatnam and informed him. Then I felt very sorry, and that you will give suitable instruction to all concerned that it will not repeat like this in the future. And if I give a report to the police, then the job of the police would go, and he will be immediately suspended, and if not, if an inquiry, it is a case of removal also. So therefore, they will conduct a scientific investigation. They will collect the evidence. They will examine the persons, because examination of the persons is a very important step in the investigation. The CRPC contemplates that they should go to the place of offense and record the statements of witnesses, the time, date, where the witnesses were examined, and the progress of the investigation on that particular day. And the investigating officer has to submit a report to his higher officials. All these things are there. So that procedure has to be followed. If a true investigation officer conduct the investigation in a correct lines, then there are good chances of giving convictions by the court. Because you are guided by the investigation, you are guided by the evidence and material collected by the investigation. Our conviction or acquittal depends upon the investigation conducted by the investigating officer. Normally, everybody throw blame on the courts. The conviction rate is 1%, 2%, or 3%. What the courts will do, if the bad investigation is in a good case, if an investigating officer conducts a bad investigation, then who is at fault? It is not for the interest of society. It is not for the interest of the victim. It is not for the interest of the relatives of the victim. So it will have an impact on the society. If in view of the bad investigation, if a person acquitted, then he will dare enough to commit another crime. Definitely will do it. So therefore, it is a high time that the investigation agency should be separated from the police wing, or a separate investigation team has to be constituted with a persons who have dedication to conduct an investigation, so that the society will live peacefully. Because the courts have no control over investigation. The conducting investigation, in what manner, how they have to conduct the investigation, is extremely domain in the police administration, not at the hands of the courts. Courts cannot give a direction to do the investigation like this, to do the examine so and so persons, or seize the records. It will not give any advice to the investigation agency how to conduct the investigation. The investigation has to be conducted by the police only. Nobody in the earth, as per our existing laws, are concerned. Police are alone competent to conduct the investigation, and interference by the courts is not at all contemplated under the present criminal jurisprudence justice system. Now, this economic pandemic situation throughout the world, there would be a delay in conducting investigation. It is very difficult for the police to apprehend even the accused also, because police are also human beings. They are not being provided with the necessary PPE kits and other equipment which will protect them from the corona. See, I saw a news in the yesterday. Some prisoners, under prisoners in the prison in West Godavari district, were infected with this corona. When some of the prisoners, 7 or 8 persons, were sent to the corona ward, 2 of them are escaped from that hospital. Then, in this situation, it is very difficult for the police or the concerned officials to apprehend them, because the fear of the corona. They are the frontline warriors, the police now at present in the corona period. So many police personnel died in the state of Maharashtra. Similarly, some police personnel in the state of Telangana, Andhra Pradesh also died due to corona. So, unless they are given some protection to themselves, it is not possible for the police to conduct proper investigation, to collect the material. When an offender infected with the corona staying in a house, the police will not dare to apprehend him. So therefore, now it's time for the government to provide all the necessary kits to conduct investigation. The police also need not fear that the cases which are conducted by them will get acquittal in the courts of law because of delay in examination or delay in conducting the cases or delay in registering the first information reports. One basic principle which runs through our criminal jurisprudence is delay by itself is not a ground to acquittal. Delay by itself is not a ground to acquittal. I will give you 2 examples how the delay has not in any manner affected. In the year 1984, Srimati Indira Gandhi was murdered by her 2 gunmen. In retaliation to her murder, the Congress men caused several deaths in the various cities of the country. The official toll of the death is around 3,500. The unofficial figure is in between 10,000 and 15,000. Several commissions were appointed, including retired judges of the Supreme Court, administrative committees. Those reports were submitted. And when the BJP government has came in power in 2013 or 12, one of the commission's report has taken place as a debate in the parliament. The debate has been accepted, and they recommended for investigation that took place in the 1984. Accordingly, in respect of one incident in Delhi, a former member of parliament, one Sajjan Kumar, was prosecuted. The CBI conducted investigation after 2013 and filed the charge sheet before the concerned district court. The district court gave a verdict saying that there was delay in examination, delay in lodging the report, all these things. The matter went up to the Delhi High Court. Delhi High Court reversed that order of acquittal and found the Sajjan Kumar, former member of parliament, under section 302 and other offences, and sentenced to undergo life, saying that the delay itself is not a ground to acquittal. The last year, December, the judgment has come. Now he is undergoing sentence in the Delhi prison. Of course, the matter is pending before the Supreme Court, as the Sajjan Kumar filed an appeal in the Supreme Court. So therefore, the police need not fear that there would be delay because of they could not examine the witnesses, they could not register the FIR. And another important case also, because the former DGP is also there, Malkonda Garu. Have you heard the former DGP of Kerala, Vijayan? He was the DCP in the Cochin, in a particular district. An encounter has taken place in the year 1970. Please remember this date, year 1970. A Varghese Naxalite leader was caught hold of, and while he was being taken to the police station, the allegation of the police is that he tried to jump from the jeep and trying to escape when by snatching away the gun and tried to open fire on the police personnel. Therefore, they opened fire. As a result, he died. There was no suspicion that it was a false encounter. The police personnel involved in that encounter were given increments, promotions, out of turn promotions, and rewards, including the DCP, Vijayan. For the first time, 25 years later, that is in the year 1998, this incident has taken place in the year 1970. 1998, a news item was found on the newspaper saying that it was a false encounter. A social activity filed a writ petition before the High Court of Kerala. The High Court of Kerala directed the CBI to conduct investigation. 25 years later, the investigation has commenced. The witnesses were examined. The documents were collected. The post-mortem was obtained from the concerned doctors. And ultimately, they filed the charge sheet against the DGP of Kerala. Now he was retired from service. He was the former DGP, Vizian. Therefore, police did not feel that because of this corona, they could not apprehend the accused, they could not examine the witnesses, they could not recollect, they could not visit the scene of occurrence, they could not collect the scientific investigation. And even in Indira Gandhi murders case also, the case has not ended even now. About 4 months back, a president of the Guru Nanak temple in Delhi addressed a letter to the Home Ministry saying that the former Chief Minister of Madhya Pradesh, Mr. Kamal Nath, and his men caused the deaths of 4 persons in the Guru Nanak temple. Now, this central government, Home Ministry has constituted a special investigation team to conduct the investigation in respect of the murder that has taken place in the year 1984. So, there is no limitation as far as the offense is punishable with more than 7 years, more than 3 years, not 7 years. If the offense is punishable with more than 3 years, there is no limitation. Case can be filed at any point of time. But the only thing is, the police have to give an explanation for the delay, reasonable explanation. How the police would explain the delay because of corona pandemic situation, they could not conduct the investigation. They could not be in a position to examine the witnesses because of this reason or that reason, or the government has not been provided with the safety kits. Even I was told that in some of the hospitals also, the frontline warriors, one of the frontline warriors of this situation, doctors were not being provided with the kits. And some of the doctors, the lab technicians, nurses are being affected with this disease. And sometimes it is resulting in deaths also. So in such a situation, we can't expect the police to conduct the investigation. As they used to do prior to the corona. So therefore, what they have to do is the honest investigating officer is conducting the investigation and gives a reasonable explanation. There will not be any difficulty for the court to accept the same. No doubt, delay in lodging the FIR or delay in sending the FIR to the court law says that FIR has to be forthwith sent to the court. Similarly, section 154 of the CRPC says that when a cognizable offense has taken place, if it is in the knowledge of the police officer, it is to be registered as a first instance report and conduct the investigation. Suppose for the reasons beyond the control of victim, and there are no other persons who can come forward with to give assistance to her, then it can be pardonable. The delay can be condoned. The delay has no effect on the trial of the cases. One example I will tell you on this aspect, where a husband was murdered in a remote village, where the entire village was united and nobody has come forward to help her, for the reason that all the villagers suspect that the deceased was responsible for giving information to the excise people who came to that village and destroyed all paraphernalia or the material used for preparation of illicit liquor. She has to go to her parents' house by crossing the jungles, by climbing the small hillocks, and to reach there, it has taken 2 days. Because if they are rustic villagers, they don't know how they can proceed. 2 or 3 days later, they went informed casually to the village officers, who is staying in a far up place. And the village administrative officer has given instruction them to give a police report. So in that process, there was a delay of 1 week in registering the FIR. So can we say that mere because of delay in the registration of the case, can we say that accused is entitled for an acquittal? Certainly not. If unexplained delay is there, even assume for a moment the police are not unable to explain the delay, still the courts will not come to a conclusion that merely because of the delay, accused is entitled for an acquittal. The court will take it as one of the grounds for acquittal. That's all. It can be taken if there are any other grounds to suspect the case. This delay in FIR or delay in sending the report to the court can be taken as one of the grounds, not as a sole ground for acquittal. By collecting the evidence, nowadays they have to conduct the scientific investigation. By doing scientific investigation I was hearing from the news, the police were saying that they used to nab the culprit by using the CC cameras, circuit closure cameras, and other devices. Even yesterday, when a big robbery has taken place in Vijayawada, 5 or 6 kgs of gold and 40 lakhs of cash was stolen. These culprits were got hold of by the police within a short period by using these devices. So therefore, the scientific investigation plays a very important role. Police are required to know from the material collected, whether it's documentary evidence or a material objects like cassettes, video cassettes, or computer hard disks, when they submit before the court, to what extent the court can take into consideration, to what extent the courts can use the contents in these devices as an evidence, so that they need not collect inadmissible evidence. If the inadmissible evidence is produced before the court, it is useless. Nowadays, I was seeing in the televisions that after accused being caught hold of any offense, he was produced in the media where the accused admits his guilt. If a cassette is produced before the court, whether that such a cassette where the accused admitted the offense in the presence of the police officer is admissible or not is the question. The precautions that may be taken while collecting the scientific investigation have to be kept in mind by the investigative officers. The Evidence Act, which is the base act, which every provision must be known to the investigative officer. What is admissible, what is not admissible in the Evidence Act? If you read the provisions of the Evidence Act, it says what is admissible in a court of law, what is admissible. One of the provisions is no admission before a police officer, no confession before a police officer need be proved. That means confession before a police officer is inadmissible. Therefore, there is no point in taking the videograph of the accused and produce the cassette before the court. The court will not look into that cassette, will not hear the contents of the cassette because it is recorded in the presence of the police officer. If the statement of the police officer is admissible in court of law, there is no need for conducting investigation. If an investigation officer says that he admitted the offense, therefore he can be punished. That is not the purport of the Evidence Act. To protect the interests of the accused also. The accused has a right to have a fair trial, impartial trial, under Article 21 of the Constitution, and speedy trial also. Fair, impartial trial is embedded in Article 21 of the Constitution. Therefore, a workshop should be conducted to apprise the police about the provisions of the Evidence Act. By reading the provisions of the Evidence Act, coupled with the decisions of the Supreme Court, certainly helpful to the investigative agency what material they can collect. If they collect and if they produce it before the court, to what extent it is admissible, to what extent it is not admissible. Because of amendment to the provisions of the CRPC, the police can conduct investigation by recording the statements of witnesses. The police also entitled to record the statements of witnesses through electronic means like video and audio cassettes. They can record the statements. They can record now. I think it is mandatory in respect of some of the offences under section 154. They have to necessarily, the police have to necessarily record the statement of the victim in certain circumstances, not all, in certain circumstances, through audio and video cassettes. And also, they have to record by these electronic means under section 161(3) CRPC, because a provision is incorporated by virtue of amendment to section 161(3) CRPC. Suppose a cassette is produced before the court. What are the factors that investigating officer has to keep it in mind? Has not been stated in the Evidence Act. Has not been stated in the CRPC. How, to what extent the court can look into the documents, how it can be proved. One example I will tell you. One of the businessmen in New Delhi caused an accident with his BMW car while several persons were sleeping on a footpath in a Delhi street. In an inebriated condition, he caused the accident resulting in the deaths of 4 persons. The car went out of the road and hit the person sitting on the footpath. A case under section 304A registered. What is the investigation to be conducted in this case? Examination of witnesses, examination of M inspector, examination of the doctor, and obtain the postmortem certificate. Preparation of rough sketch, scene of occurrence. It will be conducted. It will be the investigation at best. Even if the police officer conduct the investigation leisurely, it won't take not more than 6 months or maximum 1 year for investigation to be conducted in a 304A IPC, causing death resulting by accident, rash and negligent driving. For 7 long years, the investigation was not, charge sheet was not filed. For the reasons are obvious, because the accused was a rich businessman. Ultimately, at the intervention of the court, the charge sheet is filed. And while the trial was being commenced in a magistrate court, a scroll was appeared in the television news, New Delhi television. How a star eyewitness was purchased for a heavy price. A reporter from the television, by using a small device, recorded the conversation between the accused, wealthy businessman, the public prosecutor in charge of that case, and one R.K. Anand, who was a senior advocate in the Supreme Court, who was the defense counsel in the trial court. The conversation shows that the star eyewitness was bribed heavily to support the case of the accused. The Delhi High Court has taken a very serious view of the matter and has taken up suo motu contempt proceedings. And issued notice to all concerned in directing the reporter to produce the small tape recorder, which device she recorded the conversation. So that how that tape record is admissible in a court of law is the question before the court. In a different context, a contesting candidate of Sinnar constituency in Maharashtra, member of parliament, gave several speeches in public meetings to solicit the votes basing on his caste. soliciting votes on the caste is a electoral offence under 1951 Representation of People's Act. If it is proved, his election would be declared as null and void. The unsuccessful candidate obtained a certified copy of VHF cassette from Election Commission of India, which is a constitutional body. Simply because VHF cassette, a certified copy of the VHF cassette has been obtained from a constitutional body, can it be said that the contents can be looked into? No. So therefore, how that cassette, the contents in the cassette can be used as evidence in a court of law? When an election petition was filed before the Maharashtra High Court, Bombay High Court, challenging the election of a successful candidate is the question. In these two questions, in these two cases, Supreme Court has framed guidelines. The voice of the person who recorded the voice of that person, either VHF cassette or audio cassette, must be examined. That means if I recorded the VHF cassette, I must be examined. Secondly, the voice of that person has to be identified. Suppose the accused has made his voice. The person who is acquainted with the voice of the accused must be examined. And thirdly, there should not be any tampering of the tape, VHF or audio cassette. Because nowadays any mimicry artist may imitate my voice on the tape and produce before the court. So there should not be any tampering of evidence. And fourthly, and importantly, the contents in the VHF or audio or video cassette must be admissible under any one of the provisions of the Evidence Act. So if these four things are proved, then there would not be any difficulty for the court to accept the contents of the audio or video cassettes. So therefore, the police must know what is admissible and what is inadmissible. Suppose while conducting the case or while conducting an inquest report or preparing an observation report or preparing a site plan, what are the contents the court will rely upon it? What are the contents which are not admissible under law? They must know. For the reason, they need not waste their time. The police need not waste their time in collecting the inadmissible evidence. Because there are some of the columns in the inquest report says that they will write all the columns. That's normally the police write, పలానా పలానా సాక్ష్యం చెప్పిన ప్రకారంగా ఇలా చెప్పిన ప్రకారంగా ముద్దాయిలందరూ వచ్చి కొట్టి చంపారు అని చెప్తారు. మొట్టమొదటిసారిగా ఎవరి చేత కనిపెట్టబడింది, చివరిసారిగా ఎవరి చేత చూడబడింది. I think the state government also should know prescribe the admissible contents only in the inquest report. They can delete all inadmissible contents so that the police did not waste their valuable time on concentrating on the inadmissible by collecting evidence and fill up the documents. Because the time and again, the Supreme Court has been pointing out, there need not be any pointing out by the Supreme Court, even Section 174 of the CRPC says the purpose of holding inquest is to ascertain the apparent cause of the death, nothing else. Who caused the death? In what manner it was caused? Which weapon used by the accused? How the accused was being attacked? How he was chased? How many injuries were caused by each one of the accused? Are foreign to the ambit and scope of the Section 174. If you read Section 1, if you see any inquest document, it contains 16 or 17 columns, most of the time being wasted by the police officers to fill up those columns. So therefore, the state government also should act in accordance with the provisions. The state government should also take appropriate steps to prescribe a procedure under Section 174 to cut short the procedure and to provide columns which are necessary to help the courts rely upon it. So therefore, the police need not worry about not conducting investigation immediately after the FIR is registered. They did not
Brother, brother, just Bhanu, another speaker is waiting.
Okay, I'm sorry.
Just no, it's all right. All right. Just.
I will conclude within 2 or 3 minutes.
Okay.
So these are some of the problems that are being faced by the investigation officers, even prior to the corona pandemic period, and also more troubles the police are facing now this corona pandemic period. So I conclude this my address. Thank you very much for IFCA for giving this opportunity, and also because number of advocates are there. If anybody wants any interaction after the end of the session, you can pose any question with regard to the criminal administration. Thank you very much for giving this opportunity.
Thank you, Justice Bhanu, sir, for your valuable insights and sharing your experience with us, years of experience being in the justice system itself. And we really value your contribution. Now I welcome our next speaker, Dr. M. Malakondaya, sir. I welcome you once again, sir, to this session. Dr. M. Malakondaya worked as an assistant SP in Mulugu and Warangal Rural, and he was SP for Adilabad, Medak, and Guntur districts. He has also served as an SP of the Vigilance Cell, DG of Civil Supplies, and Director of Anti-Corruption Bureau, DIG of Guntur and Nelluru Range. He has been working as MD of Andhra Pradesh State Road Transport Corporation before being appointed as the Director General of Police and Head of Police Forces of the state of Andhra Pradesh. I welcome you once again, sir, and I hand it over to you so that you can share your valuable insights with us and enlighten us this evening. Sir, we are actually not being able to hear you.
Your voice is not, your audio is not coming, sir. Unmute, please.
Please try now, sir.
I don't think it's still not audible.
There is some problem with the audio, sir. Malakondaya garu.
Call him on his mobile if you can.
Yes,
Yeah,
sir, I'm
trying.
trying to, but the phone is not reaching, sir.
Dilip, you unmute him.
Yes, sir, I have already done, sir. Sir, please pick your phone, or maybe you can try clicking on the three dots button, which I told you, in the same manner like you joined previously. If you can click on the three dot button, it will show you audio connection button, and you can rejoin by disconnecting and reconnecting over there. We are not able to hear you, sir. Either you can pick my call. I'm trying to call you, sir. Hello. Yes, sir. Maybe you can try disconnecting, sir, and your headphones, and you can directly speak with your laptop voice, sir. In that way, it was coming previously also. Please rejoin the audio, sir. In the same manner, sir, click on join audio button. By clicking on three dots, clicking on audio
But you
connection.
click on three dots and and switch off and switch on again. Just try.
Justice Banu Garu and Justice Prakash Rao Garu. It's a very timely webinar on a very important topic. I must thank the ICFI for inviting me to join you on this webinar. It's an unprecedented challenge for the police administration and also for the government, because this is a pandemic. The normal process of investigation normally take a back seat whenever there is a law and order issue or any public order issue. So in this case also, the investigation normally has taken a back seat, because the first priority for any government or for police administration is to tackle the crisis on hand. So yes, I do agree with the observations made by Justice Banu Garu and also Prakash Rao Garu on a number of issues. How investigation, particularly the criminal justice system, it gets affected because of this pandemic and police response. In the initial stages, everybody thought that this pandemic will go over a period of time, in a short span of time, and the main concentration of the police administration was to contain the infection to prevent people from coming onto the roads. So that was their main aim. Yes, there are some mishaps in the process. There are some, I should say, high-handedness on the part of the cutting-edge-level police personnel at different places in the country, and the treatment of the migrant labor at different places. A number of issues were there. But as time progresses, we are able to, overcome many of those issues. But when it comes to the investigation of crime, no delay can be, justified. Because the CC10S project, the government of India invested a lot of money, and people can register their complaints online. Once the CC10S project, it's fully made useful, then these problems can be overcome. Justice Bonagaru has mentioned a number of issues. I fully agree with you. Justice Bonagaru's observation, he has got rich experience in on the criminal side, in judicial side. True that number of the investigating officers, generally whatever they do investigation, it is the responsibility of the superior officers to ensure that they collect relevant evidence, admissible evidence. It is to some extent the failure of the supervisor officers at different levels to give proper importance and focus for this very important work of investigation. And cases do fail in the courts of law, so they cannot withstand the rigorous cross-examination of the defense counsels. So in order to ensure proper conviction, to ensure justice to the victims, investigation has to be thorough. No material facts should be omitted in the investigation. No delay, unexplained delay should be made in the investigation. And these are very rudimentary things that all the police personnel who are connected with the investigation are taught in the police academies, and later also, because the courts also, they do make observations about the shortcomings in investigation. Unfortunately, these judgments many a time are not read by the concerned. So with the result, the superior officers won't be knowing the shortcomings of investigation. Because the person who investigated the crime, the person who files a charge sheet, the person, by the time the judgment is delivered, many of these officers are transferred out. And that sort of delay is taking place in the whole process of criminal justice administration over a period of last 3-4 decades. There are any number of cases, even charge-sheeted cases are pending in the courts. We have less number of investigating officers and also less number of courts to try. These the trial courts are few in number. It is it's an amazing fact that thousands of cases, appeals in murder cases are pending even in the higher courts. So this sort of system we cannot allow to continue, because ultimately the victims need to get proper justice in this system. He has mentioned that Justice Bana has mentioned a number of cases, particularly in Kerala, where the delay, even if it is there, if it is properly explained, the courts take into account, which is true. If the investigation is fair, if the investigation is timely, if the investigation is proper, courts also do appreciate the work done by the investigating officers. He has mentioned about the inquest report, that there are about 26 columns actually. These 26 columns, some of them, the purpose of the inquest is very simple. That is to find out the apparent cause of death. But unfortunately, the legacy is being continued, and those shortcomings, the same inquest report is there for all the types of cases, whether it is a serious murder case, whether it is a small apparent road accident case, and all those issues. So this needs to be checked. Recently, the Supreme Court has asked the CBI, the Government of India, the Minister of Home Affairs, to fix time limits for the investigation. And that is still being engaged with. The Government of India is now engaged with that issue. And from our part, the Andhra Pradesh has submitted those proposals because no simple cases cannot be find taking so much of time. He has mentioned rightly about the BMW case of Delhi High Court. It has taken about 7 years, something like that. So these are definitely, I think, infractions on the part of the local administration, and the courts are coming heavily on such shortcomings. But ultimately, the executive is responsible. The police administration, whoever is investigating the case, is held accountable by courts. But there are many instances where the courts are also not passing adverse comments. Earlier, when we joined the police force, we were a little apprehensive whether any court would pass any strictures on the investigation. So we used to debate, we used to talk about such cases in the crime meeting and try to overcome those shortcomings. But probably because of overload of work both in the police administration and also in the criminal justice system, that's in the courts also, I think these things are not happening. There are a number of issues which require correction at different stages. But this COVID is a pandemic which is a very, very serious issue that the frontline warriors, be it police or doctors or nursing staff, they're all affected by these COVID. And the Justice Bono has mentioned about 2 cases of prisoners who are infected with this COVID, escaped from the prison. So such cases do come across. So we do come across. There are some of the police personnel also became victim to COVID in the recent past in different parts of the country. Because it's not only the controlling pandemic, but it is a sort of fatigue also. It gets into the police nursing psyche because they have to be on the roads and they have to be on the lookout for a long time on the streets. So public cooperation is also required in this sort of situation. However, the investigation part, because there are 2 issues. One is containing the infection from spreading to other people. That is the main issue on hand for the police administration and also for different government agencies which are involved in this whole issue. Apart from the containing and spreading the infection after the lockdown is lifted. So long as lockdown was there, the cases were less. But once the lockdown is relaxed, then the number of cases are mounting day by day. So this is a challenging task because the priority for any government is to contain the infection, and investigation in such circumstances do take a backseat. It happened even earlier also when we were working in the Naxal-infested districts. Investigation is to take a backseat, and the law and order takes the first priority. That's the reason why earlier asked to have a separate investigating agency which should be dealing from the normal law and order machinery, so that the process of investigation won't get hampered. So that was the idea, and some of the state governments were asked to implement. Some of the state governments did take steps. Like Punjab has taken steps in this direction. In our state also, to some extent, these guidelines were being followed. But there is the complete separation of investigating agency from the law and order machinery is yet to take place. So once that happens, so investigating agency won't get dragged into the routine police functions, so that they're free from the normal police duties. They can devote full attention to the the original task of investigation, and they can be trained as such because investigation is a specialized job. There are cases where investigation is very simple, no need for any extra legal knowledge because there is oral evidence, there is apparent cause of no incident, and all the evidence is apparent for any discernible eye. But there are cases where investigations won't be that clear in the initial stages. So where they need to collect a lot of documentary evidence, where they need to verify that evidence and put before the court in a format that is acceptable to the court. So that requires a specialized talent. So that talent won't come in a short span of time for all the police personnel. So in number of developed nations, the investigating agency is a separate body and they are well trained and they are equipped with all the skills that are necessary and also with the techniques that are required. But in our country, unfortunately, even though the crimes are increasing and not only the number of crimes, but also the sophistication with which the criminals commit crime is also increasing. Therefore, we require specialized agencies for investigation to ensure that the victims get justice in a time-bound manner. Otherwise, what is happening is the offenders are taking advantage of the loopholes in the system and the people are put to loss. So this is a thing that cannot be, allowed to continue forever. In fact, a number of heinous offences cases, justice in some cases, particularly, especially grave crime, we call in our police parlance, where they use explosives, where they use weapons, where they use such deadly weapons to commit crimes. They need to be tackled with urgency. Of course, those issues are still there. In these difficult times, police are trying to do their best to first contain the spreading of infection and attending to the pressing law and order issues and also very serious crimes. Luckily, because of the lockdown, the crimes also have come down. Quite a good number of routine crimes have come down, whether it's property offences, whether it is accident cases, whether it's normal serious cases have come down. But once the lockdown is lifted, again there is a chance that these cases again will start mounting them. So this is a very challenging time, and then I think the police administration has to gear up fully to meet those challenges. Thank you very much. I think I'll stop at this. Thank you. Bye.
Thank you, sir, for
Thank you,
joining
sir,
us.
Thank you, sir, for enlightening us with your experience and your valuable insights and all the information that you gave us, and with regards to COVID-19 also. I think I think maybe we can now proceed with the question and answer session. Director, sir, can we proceed with the question and answer session?
Let us sum up and then we'll go for the question and answer sessions.
Okay, sir.
Today we have the great hearing from Prakash Rao Garu, Justice Prakash Rao Garu, Justice K.C. Bhanu Garu, and my friend Mr. Malakundaya Garu. All these people have spoken about the practical experiences. It's a great to hear that. Everyone has come with their opinions and also the problem faced by everyone during this particular criminal justice system and also more particular with the pandemic situation. As I already told you in the beginning, we are living in a society, that too diversified society. We have some negative points and positive points. We have the strengths and weaknesses with us. Criminal justice system in India has a great processes, well-established systems. Similarly, police administration is also very well defined, trained, strengthened with a different kinds of the knowledge. However, both the systems are having a lot of problems. Shortage of the staff, pending files, and expertise needed for that particular case at the both the places is one of the requirements of the things. Under these circumstances, we are having the hit from our unwanted guest, Corona, that's a COVID-19. It has shattered everything. Though a person is in common life, they have totally disturbed. Now we are only having a lot of apprehensions how to come out of this particular pandemic to be safe. That is number one. To work safely. Number two. To provide productivity to the society. Number three. To give solutions to the problems which we are facing during our day-to-day life. Under these circumstances, all these systems cannot work as in isolation. We have to work in a pluralism. That's what was lies. In a society where diversity is there, police administration has to do its work in a different dimensions, in to protect the people's rights, to go for the assistance for the criminal justice system as a part of it, the investigation. All those things have to be carried by the police administration system. In addition to this, it also should work for the containing the spread of the pandemic. That is a COVID-19, which is very challenging. Some of them can be postponed, but not all of them. When you talk of the COVID-19 situation, this contamination is going to be very important part of it. So more attention has to be given to this particular part as a priority, and people should work together to fight with this COVID-19 and the spreading of the disease. We have seen the number is mounting every day. It has crossed now 13 lakhs plus, and deaths have started across nearly 30. If you see our states also, every day the thousands of cases are being reported. We do not know what is going to happen tomorrow. We do not know what is going to happen next week. The things may further deteriorate in this particular process. Now we have to take a cautious decision to work together in this society where we have to balance everything. One is protecting the individual rights in the name of pandemic, in the name of controlling the this contagious disease. We should not trouble the common people. Similarly, common people's rights should not be upheld much, so that the delusion of the protection towards this particular pandemic is to be done. So there is a requirement of balancing both the things. Now, police administration is at a crossroads. It has a lot of responsibility on the shoulders. They are the fighters. They are the frontline organizers for all these things. We have to appreciate the work they have already carried so far, and we should help them in this particular disastrous position or health emergencies to support them to do their duties. Similarly, as Mr. Prakash Rao said, we should not close everything for say, with one or other fear. We have to do something every day, improve our quality, improve. We have to accustom or we have to customize ourselves, acclimatize ourselves with the things happening. We have to face the challenge by living by living. We cannot postpone our living for the sake of something else. So we have to live, and the corona also will be going to live with us. But we have to be very careful when we are going to do that. We should not be take lenience, or we should not be negligent. All people, whatever that is stated by the health experts, there's a social distancing part, are having the mask with us, taking this timely decision, and about the hygienity. All those things are to be followed in order to protect ourselves in this particular pandemic situation. The courts are doing that better with whatever the resources they have, and police administration is also doing wonderful thing during this particular part. As a result, in this social pluralism environment, everyone has to do their own duties perfectly. With this, I now ask Anvesha Panigrahi to take the questions and complete the process. Anvesha.
Yes, sir. Thank you, sir. Thank you, sir, for summing up the session so nicely. We'll go ahead with the question answers. My first question is, as the questions are not pointed out to anyone specifically, all panelists are welcome to answer the questions. Sir, my first question is that delay in investigation during the pandemic due to the police officers being engaged in other activities results in delay of serving justice, delay in trial, and although it's not excusable, it is happening. So, does it give rise to impunity in criminals and triggering more serious offenses? And also, how do we ensure that such damage which is being caused by the late justice be restored? I think Prakash Rao sir is question.
No, just Banu Garu. I think you can answer. Yes, Banu Garu is there.
Yes,
Yes,
sir.
yes, yes. I will
Yes,
answer.
you can answer, Mr.
My audio is audible?
Yes, sir, it's very much audible.
See, I already told you that delay in conducting investigation or conducting illegal investigation, even assuming for a moment, if the investigation is illegal or the investigation is improper, that will not have any impact on the trial of the case. It will not have an impact on the victim's case. Because of lack of training, lack of experience, the police officers may do sometimes, not always, some mistakes, irregularities, illegalities. Even if you say illegality, that is illegal means the police conducting investigation totally against the statutory provisions. Still, it will not have any impact on the trial of the case. See, the basic principle which the Supreme Court has laid down in so many cases, that illegality investigation may not affect any during the trial of the case. It will not have any impact on the trial of the case. But when the accuser is able to show that illegality is committed by the investigating officer with ulterior motive or in a vindictive manner, the courts suspect such investigation and take it as one of the grounds to acquit the accused, not a sole ground. Illegal investigation is not a sole ground. Delay in conducting investigation is not a sole ground. Delay in FIR is not a sole ground. But only thing is, the police have to explain the delay, why they have not conduct the investigation in a particular period, why they have not examined the witnesses, why they could not be in a position to go to the scene of occurrence to collect the evidence, why they have not went to the houses of the village to record the statements of witnesses. Suppose a village where the corona is being affected totally and it is a containment, it was declared as a containment area by the local authority, then the delay will not have any effect on the investigation or the trial of the case. So this basic principle, the investigating officer has to keep it in mind. They simply say in the investigation that because of this reason, I could not examine the witnesses, I could not go to the scene of occurrence, I could not apprehend the accused. Suppose accuser was suffering with attacked with corona. See, how can the police dare enough to go to him and arrest him? Suppose the accused want to spread this coronavirus to the police officers. So no police officer will dare enough to apprehend the accused in such a situation. Therefore, these have to be explained by the investigating officer to satisfy the court, the delay.
Yes, sir. Thank you, sir.
Let me add a few lines for this.
Yes, sir.
As per the question, delay due to the COVID, delay in investigation because of the COVID may cause, but it is better to have a perfect investigation, not a hurried investigation. If you go for a hurried investigation, there is it will be equivalent to buried the facts. We have our criminal justice system, though 99 people who are accused may be escaping, but one innocent should not be punished. That is our principle. there is a possibility of delay of some cases because of the COVID or any other reasons. General principle we have to take is the effective and efficient form of investigation is required that has to be presented in the court of law. As our respected, our Honorable Justice Kakesu Banu already told, delay if explained with a reason, with a reason that can be condoned and effective results will come. We do accept the fact COVID may be causing some delays in addition to the regular delays, but we have to go with it. We cannot infuse or many people into the system at a short notice. It is difficult people to train to investigate in this short time. So what are the people are there with us? We have to allocate and also distribute for the works pending with us. With these things, we have to go along with the delays. Thank you very much.
Okay, sir. So the next question is now that the courts are moving to become virtual courts and some courts in urgent situations they are taking up cases virtually, what is the evidentiary value of evidence which is recorded through virtual hearing? As there is no specific law addressing the situation, is there any principle behind it which addresses the same?
No, in the virtual hearing, I think they will give some. You have given that code email and code number that will be given by the Registrar General to the concerned advocates to argue the case. So therefore, when the court is permitting, because you have rightly pointed out that there is at present, because the situation come about 3 or 4 months by the beginning of this year, and no law is so far enacted to meet such a situation. Nobody is expected this situation, but still courts are allowing the persons to argue the case virtually through this video virtual conference. I may tell you that Evidence Act has been amended so that a person can be examined anywhere in the country, anywhere in the world. Suppose a doctor has given a treatment to a patient in America. It is very expensive for the doctor, the expensive for the victim or the accused to produce him before the court of law. Therefore, he can be examined by a virtual hearing through this video conference. Only thing is the identity of that person who is giving statement, the identity of the person who is arguing the case virtually has to be established. If it is established, it can be taken note of, and the courts will give judgments basing on the virtual hearing also. So it is permissible under the Evidence Act. In view of that, in the same in an analytical situation where the evidence, when evidence of a witness being recorded through video conference, which can be admissible under the court of law. In the same analogy, the virtual hearing by the advocates is also admissible, and the courts are permitting. The only thing is, identity of the advocate has to be established. Identity of the person who is making a call through video conference or virtual hearing must be established.
Okay.
Let me add a few sentences for this also.
Yes, sir.
During this COVID-19 only, we are starting the virtual courts. But evidences to virtual media is already established principle. Long, maybe 10 years back only for the first time in Hyderabad, the witnesses were examined by video conference was there in the Cherlapalli jail. So whenever there is no possibility of transporting the accuser from the jail to the court, there are some occasions where the evidences or the examination of the people were done. And the evidence, electronic evidence or evidence, digital evidence is already accepted model of evidence. So we have to identify, we have to find the two differences. That is, process of hearing the cases through virtual courts, number one, examining the witnesses, submitting the evidences through electronic media, the two different part of it. The second is already established. We have the Evidence Act amended, CRPC amended, and so many things also there with the help of that particular Information Technology Act 2000, which has been amended in 2008 and thereafter. It has given some kind of inputs for this particular purpose. And virtual course may not be permanent for us, though we have to go for some more days. We have to also agree that the virtual course are not replaceable for the real course. Real course has its own merits, and virtual course will have its own merits and demerits. At present, under this particular situation, we have to go ahead with these things. We have to face the situation. We have to solve the situation with amicable, with efficiency, whatever resources we will be having. Thank you.
Thank you, sir. Thank you, Justice Bhanu, for addressing the question. The next question is with regard to cases which, Justice Rao already said, that domestic violence cases have increased during the pandemic. And along with domestic violence cases, there are two other kinds of cases which have increased: cybercrime cases and child sexual abuse cases. So the question is regarding the child sexual abuse cases, because they are very sensitive and serious nature of cases. How do we address crimes like that, and how do we ensure that the police has a hand in preventing the situation before it arises?
A good question has been asked by you. Not even a pandemic situation like Corona, but even still, this Protection of Children from Sexual Harassment Act 2012 or 13 has been enacted by the Parliament. There is one provision in the one section in that Act, 2013 Act, POSCO, Prevention of Crime Against Sexual Offences Against the Children and Women. I will read that provision. I will say that provision is Section 30 of the Evidence POSCO Act 2012, which says if a person is prosecuted, just to please remember the word prosecuted. If a person is prosecuted for the offences under Section 3, 5, 7, 9 of this Act, because we are talking about the offences against the child, sexual offences against the child. If a person is prosecuted for any of the offences under the Act, 3, 5, 7, and 9, the presumption is that the accused has committed the offence. If a person is prosecuted, the presumption is that person is presumed to have committed the offence, unless the accused discharged the burden of showing that he has not committed the offence. That means the traditional proof of burden of proving the case beyond all reasonable doubt, which is in our system in all the offences, that the burden is always on the prosecution to establish the case beyond all reasonable doubt. The burden of proof never shifts unless law says, unless a provision says. So this provision is incorporated in section this POSCO Act, saying that if a person is prosecuted, what is meant by prosecution? Prosecution is initiation of registration of the FIR. Prosecution commences from the date of registration. They can simply conduct the investigation, record the statements of witnesses, and produce the evidence, produce the material before the court. That is enough. That is enough for the prosecution. So therefore, the prosecution need not examine the witnesses. The prosecution need not examine the witnesses in the court. It is the duty of the accused to discharge his burden by showing preponderance of probability that he has not committed the offense. The burden is on the accused to establish. It's not for the prosecution. So therefore, there's a far-reaching consequences. Still, it has been enacted in the POSCO Act. We are giving protection to the sexual offences against the child. Therefore, the courts must take a note that instead of adducing evidence by the prosecution, the courts must direct the defense or the accused to adduce evidence on his behalf to show that he has not committed the offense. So therefore, when the law says in a particular manner, that procedure has to be followed. So it is a special law. General law is Evidence Act 101. If a person wants to prove a particular fact, the burden is on him. This special provision prevails over the general law. That is basic principle. So therefore, this special provision prevails over the Evidence Act, and therefore the burden is on the accused to establish to get over the situation, to meet the offense are being committed against the innocent woman. Recently, I also saw in the news that when a COVID patient went to the bathroom, she was being raped or molested by some sexual harassment has been committed by another COVID patient. There is a situation where even in during the pandemic period also, when a woman was infected with a corona, she is being attacked. That is the reason why so many changes have taken place in the Moscow Act, which is an important act. So therefore, this has to be kept in mind by the courts. Unless, though it is totally against the general principle of law, but still there is a law. That law has to be followed. Till it is struck down by the constitutional courts, it is a valid law, and the courts can take note of it. Even in several judicial academies also, I pointed out that we need not examine any witnesses on behalf of the prosecution in view of the language employed in Section 30 of this POSCO Act. When a person is prosecuted, it is presumed that he has committed the offense, unless contrary is proved. That is the law.
Thank you, Justice Banu, for your wonderful reply for the question. And now let me say one thing. There is a talk that the domestic violence is increasing. But do we have any authenticate data for that? In this particular pandemic area, is there any kind of research went on this, how to find out how many domestic violence cases are there during this particular period? If this pandemic is not there, what would have been there? Any comparison? Increase of 10%, 15%, 20% of the domestic violence cases during this particular period? Do we have anything else? First, we have to find out how many cases happened during particular part. Then compare to the old data. If this is not there, how many would have happened? Then compare. Automatically, when people are there at one particular place, irrespective of this domestic violence, even friends, 4 or 5 people together sit together, argument starts that may go into that different kinds of ending. When people are at the house and people are expected to be calm, and it is not possible, there may be some kind of discussions in the house that may be converted into some more disputes or troubles. There's a possibility, but we don't have any authenticated data. We may have data from newspapers which is not authenticated. Unless we have the authenticated data, we cannot say this. About the cyber crimes, the COVID-19 has nothing to do with it. Cyber crimes is a part of everyday life. Whether COVID or not there, every day it is increasing. In future also it increases. Child abuse is also similar kind of thing. So we have to be very careful when we think about these things. Thank you very much.
Thank you, sir, for addressing the situation. And Director, sir, also thank you for addressing it from a neutral standpoint. So the next question is regarding encounters. Now, the police have taken up quite a lot of responsibility and have been frontline warriors, and they have in fact put themselves at risk to save our lives. But situations like the Benix case and prior to that the Disha case, and there are other cases of police brutality which has taken place not only in India but also all over the globe. So, do we have an answer for that? And is it because of the COVID situation, or does it happen rather often and we don't get to know about it? And what is the answer to it? How do we address the situation of yeah?
Encounter, in my personal opinion, is totally against constitution and statutory provision. It's totally against, because the investigating agency cannot take the law into their own hands and punish the accused. The punishment, power of giving punishment is only on the hands of the courts only. Nobody in the earth, I'm repeating, nobody in the earth can punish where a person has committed an offense. So therefore, encounter may be encouraged by the people because people want instant justice. Instant justice. If a person goes to the court, he may not get instant justice. We have to attribute the lawmakers for not constituting number of courts. In almost Western countries, almost all Western countries, very small countries like Spain, Portugal, Canada, Argentina, in all these countries, for every 10 million people, there are about 40 to 50 courts. There are about 40 to 50 courts. Whereas in India, it is only 8 or 9 courts are there. So where the courts in India are unable to give the instant justice. Number of years are being caused because of how many cases would be piled up in this during this COVID period? Almost all virtually. And second reason is for now, the courts, the vacancies in the court are not being filled up in a time frame manner. See, when a person joined in the judicial service, the appointing authority would know at what time you would retire. You would retire. So, by taking the retirement, number of persons retired in a particular area, the process has to be commenced before 6 months or 1 year, so that the vacancies should be filled up. So as far as the encounter is concerned, the people want instant justice. Therefore, they are encouraging. So many people praised the police officer who encountered the offenders. No, it is a heinous offense. But law does not give any permission to the police officer to give punishment. In such a case, if they want, the police want to give any punishments, there is no need to establish any courts at all. The police can give punishments after conducting investigation, after examining the witnesses. Therefore, the encounter is a totally unconstitutional, and as a matter of fact, a full bench consisting of 5 judges of Andhra Pradesh High Court in a composite High Court gave a verdict that a first information report has to be submitted before the court for with regard to the incident of encounter, because it is for the court to decide whether as a self-protection the police opened fire or intentionally they opened fire. That has to be proved before the court of law. They can't say that the police can't say that while accused is being running away, or the accused tried to snatch our guns and try to open fire on us, we opened fire, therefore he died. That cannot be accepted. That is not acceptable in view of the constitutional provisions.
Okay. Yeah, so thank you so much, sir, for addressing the question. And I think we've come to the end of the session now, and I'll move to the vote of thanks, and then we'll end the session. First of all, I would like to thank our director of Iqbal Law School, Hyderabad, Professor A.V. Narasimha Rao, sir, for his constant support, guidance, and for successfully helping in organizing this webinar today, very informative webinar today. I would like to thank all our panelists, Honorable Justice Prakash Rao, sir, Honorable Justice Bhanu, and Dr. Malakondaya, sir. Apart from that, I would like to thank Justice Yethurajulu, who is there with us today and has attended the session. I would also like to thank our technical support, Mr. Dilip, who has helped a lot in organizing the webinar. Apart from that, I would also like to thank all my colleagues at Iqbal Law School, Hyderabad, who are constantly supporting us in such webinars and all other endeavors. And last but not the least, I extend my thanks to all the participants who are here, all the attendees who have raised significant questions and who have given a very good feedback and comments. And thank you once again, one and all present here, and those who are not present here but are behind the screen in organizing the webinar. And with that, we would end the session. Once again, I extend my thanks to all the panelists, including Director Sir and Philip Sir, to have successfully organized this webinar.
Thank you.
Thank you, everyone, and apologies for the technical inconvenience which has been caused because of some network issues. You guys will receive the feedback form within a week or so. Sorry, feedback form has already been provided. All those who have filled the feedback form, certificate will be provided after a week. Thank you.
I would also like to add that please fill in your email IDs correctly in the feedback forms, because earlier we had faced issues. If you don't fill in, because those email addresses will be used to send you the certificate. So kindly recheck once again before filling in the form. Thank you. Shall we end the session, Dilip sir?
Yes, ma'am. Thank you.